The decision Innovatio IP Ventures made in 2011 seemed like a clever legal arbitrage. Acquire a portfolio of fundamental Wi-Fi patents, then, instead of fighting tech giants, target their customers. The plan: send over 8,000 demand letters to hotels, coffee shops, and restaurants, each one a small business with no legal team on standby, demanding $2,300 to $5,000 per location. Just below the cost of hiring a lawyer. It was a calculated gamble on economic fear, a strategy designed to bypass the powerful and prey on the weak. But the architects of this plan missed a fatal flaw in their core asset. The patents they bought came with hidden strings attached, a legal obligation buried in fine print they believed they could simply ignore. To understand the decision that led to Innovatio's spectacular failure, you must first understand the asset they acquired and the company that originally created it. The intellectual property originated not with Innovatio, but with Broadcom, a leading semiconductor manufacturer. In February 2011, Innovatio IP Ventures, a non-practicing entity, acquired a portfolio covering foundational technology codified within the IEEE 802.11 standard, the technical blueprint for modern Wi-Fi. The asset was potent, covering technology embedded in hundreds of millions of devices. Innovatio, however, had no intention of building a single product. Its business model was purely assertion. This strategic acquisition carried a critical legal detail. Because the patents were necessary to implement a universal technical standard, they were classified as Standard Essential Patents, or SEPs. This designation imposes a binding obligation. Any entity wishing to create a Wi-Fi compatible device must practice the technology. There is no alternative design path to achieve compliance. This ubiquity gave the patents immense potential leverage, but it also contained the seeds of their owner's downfall. The limiting factor was a commitment to license the patents on reasonable and non-discriminatory terms, known as RAND. This pledge, made by the original patent holder to the standard-setting organization, ensures essential technology remains accessible. The RAND commitment travels with the patents, binding any future owner. With this legally potent but constrained portfolio in hand, Innovatio faced a strategic choice: pursue the deep-pocketed manufacturers who understood RAND defense, or cast a much wider, more vulnerable net. Their decision would redefine the boundaries of patent enforcement. Innovatio executed a novel and aggressive legal maneuver. Instead of confronting the sophisticated legal teams of Wi-Fi equipment manufacturers, it bypassed them entirely. The new targets were the end users, thousands of small businesses across the country. Beginning in 2011, a wave of over 8,000 demand letters was dispatched to individual hotels, coffee shops, and retail chains. These businesses were not technology companies. They were simply entities offering a standard amenity to their customers. They were accused of patent infringement for using off-the-shelf Wi-Fi equipment, a technology they had trusted as a basic utility. The strategy was a calculated exercise in economic coercion. Each letter demanded a settlement payment, typically ranging from $2,300 to $5,000 per location. This figure was not based on the intrinsic value of the technology, but on a simple, brutal calculation. It was substantially less than the tens of thousands of dollars required for a small business to hire legal counsel and mount a patent defense. The demand created an asymmetric trap, forcing compliance through financial pressure rather than a determination of legal merit. It was a business model predicated on exploiting a systemic vulnerability where the cost of justice far exceeded the price of capitulation. This siege against a vast and unprepared customer base could not go unanswered. The equipment manufacturers, companies like Cisco and Netgear, realized that an attack on their end users was an indirect attack on their own market. A defense of the coffee shops and hotels was now a necessary defense of their entire ecosystem, triggering a critical legal confrontation that would escalate to federal court. 8,000 letters went out, 3 companies answered. Cisco Systems, Motorola Solutions, and Netgear didn't wait to be sued. They filed first. declaratory judgment actions, legal petitions asking a federal court to settle the question before Innovatio could pick off another cafe owner, another hotel manager, another franchisee paying a licensing fee they never owed. Their argument was surgical. Innovatio's patents weren't ordinary intellectual property. They were standard essential patents, the kind that come with strings attached the moment you contribute them to an industry standard. Broadcom, the original developer, had committed to RAND licensing terms, reasonable and non-discriminatory. That meant anyone practicing the standard, anyone using Wi-Fi, was entitled to a fair rate, not whatever Innovatio could extort from a corner bakery too small to fight back. The manufacturers' filing made the math plain. Innovatio had built an entire business model around licensing at the wrong level of the supply chain, squeezing end users for $2,300 to $5,000 per location when its RAND obligation pointed upstream toward the companies that actually built the equipment. 3 separate lawsuits, 3 manufacturers, 1 judge. These cases consolidated in Chicago under Chief Judge James F. Holderman of the Northern District of Illinois. The designation, 2303 Moldovan Leis. Holderman now held the central question in his hands. Was Innovatio's end-user shakedown compatible with the promises embedded in those patents from the very beginning? The courtroom became the stage where 2 fundamentally incompatible business models would collide, and only one could survive. The litigation before Judge Holderman pivoted from a question of infringement to a question of pure economics. With the patents established as standard essential, the court was compelled to define the boundaries of a reasonable and non-discriminatory royalty. Innovatio argued its license was worth a percentage of the value the end user derived from Wi-Fi, effectively tying its patent to a hotel's revenue. The manufacturers countered with a far more constrained framework. They argued that the patent's value should be tied not to the end service, but to the smallest component that practices the invention, the Wi-Fi chip itself. In a landmark ruling in October 2013, the court adopted the manufacturer's logic. Judge Holderman established a formal methodology for calculating the RAND rate, concluding that the proper valuation basis was the, quote, smallest saleable patent practicing unit. The court rejected Innovatio's expansive theory and focused exclusively on the chip. After a detailed analysis of comparable licenses and the patent's technical contribution, the court arrived at a precise figure. The reasonable royalty for Innovatio's patent portfolio was not thousands of dollars per location, but 9.56 cents per chip. This single judicial finding dismantled the entire economic foundation of Innovatio's campaign. With its primary assertion now valued in pennies, Innovatio faced the impossible task of justifying a business model that had been rendered legally and financially obsolete. The court's 9.56-cent ruling was not a suggestion. It was a death sentence. The final confirmation came in February 2014. Cisco Systems settled all claims for its global customer base, paying Innovatio a total of $2.7 million. When averaged across the devices Cisco covered, that payment worked out to roughly 3.2 cents per unit, a figure that formally validated the court's methodology and collapsed Innovatio's entire licensing campaign. The gamble had failed, not partially, definitively. But the case's legacy extends far beyond what Cisco paid. The Innovatio ruling addressed how standard essential patent royalties are calculated. The court clarified that for standard essential patents, the royalty must be based on the smallest saleable unit that practices the invention, the Wi-Fi chip, not the hotel lobby it connected. The judgment gave courts a clear, repeatable framework for dismantling inflated royalty theories. Yet this protection has a boundary. The Innovatio decision hinged on the specific legal status of standard essential patents and their attached RAND commitments. Not every patent portfolio carries those constraints. So as one form of assertion is contained, a harder question remains. Have we truly closed the door, or merely shifted the battleground, leaving small businesses exposed to the next wave of claims that don't come wrapped in RAND?